8,025 waived their revocation hearing, and 105 went forward with their revocation hearing. Let me emphasize again that a revocation hearing is where you stand in front of the board and advocate for yourself not to be incarcerated anymore. And folks are not availing themselves of this opportunity because there's a culture that says it's not worth it, it's a waste of time, we're gonna pressure folks into waiving these hearings. And then after you do or do not go in front of the board, they are giving inadequate notice of what the decision is based on. That's another element of due process, which we'll talk about, is that if they say, yep, we're locking you up, we're revoking your parole, they have to say why. And the decisions of the parole board can be very arbitrary. All sorts of, I think, implicit and explicit biases play into it, of course, whether that's racial bias or just bias against people who may have committed certain, committed certain crimes, so that folks are not standing in front of the parole board on the rare occasions that they do on equal footing. And so now Amy is going to move into the litigation that we undertook to try and fix some of the problems we identified in the process.
Thanks so much, Pat. Sorry for messing up the screen there. And I realized that I said, oh, type a question in the chat if you have it, and I can't see the chat right now. So if you really have a burning question, feel free to interrupt me if you can, or else we'll make sure there's time at the end for them.
I'll monitor the chat as well.
But thanks, Pat. I appreciate it. So Pat did a great job of sort of explaining what the world looked like in 2017 when MacArthur filed this class action lawsuit in federal court. Thousands of people being sent back to prison every year without being informed of their rights to a hearing or their right to counsel in some circumstances, not being screened to determine whether they were eligible for state-funded counsel, no one being provided an attorney, and not being informed of the allegations against them. So it was really, I think we call this presentation the machination of reincarceration. It really was this machine, this process of reincarcerating people who are on parole supervision, like on autopilot, just kind of churning them in without consideration for the human impact this was having on our clients, our class members, their families, and their communities. But the litigation itself was actually very simple. It boiled down to a due process challenge to Missouri's parole system, and we'll talk about what that means. It was a case that was seeking injunctive relief, which means forward-facing prospective relief. It was seeking to change the system, to change the way that the parole revocation system is conducted in Missouri. It wasn't seeking money damages. And this case is unique in my years of litigating. I've never had a case where the state basically waved the white flag and admitted liability like they did here. They initially fought the case tooth and nail, but when we filed a motion for judgment in our favor in late 2018, a motion basically saying there's no disputed fact here, judge, you can enter judgment in the plaintiff's favor based off of what we've presented to you on the papers. The state agreed. They said, yes, at the time the complaint was filed, we weren't doing what we were supposed to be doing under 50-year-old Supreme Court precedent. Really no excuse. They also did not file any objection to class certification, right? So by proceeding as a class action, this lawsuit could secure a benefit to all adults on parole supervision in Missouri, as opposed to just the 6 or so named plaintiffs in the case. It's a way of securing systemic reform that inures to the benefit of a large number of people who are similarly situated. So not only was DOC saying, yes, we admit these problems exist, but by not objecting to class certification, they were saying, we admit they exist and they're not just one-off, these are systemic issues. Something that might jump out to folks as you look at this timeline of the litigation that's on the slide in front of you is how much time has passed since this lawsuit was filed, over 3 years before we were able to secure a remedial order. And Pat and I are trial attorneys, and I think that litigation is a very powerful tool for effecting reform, but it's not always fast moving. And now we'll talk about in a few minutes, we're mired in an appeal that's going to drag it out further. So it's not perfect, but during the course of this 3 years of litigation, DOC did make some quote unquote voluntary changes to their policies and procedures, which I'll talk about. And then ultimately we secured a really great judgment from Judge Boo in the Western District just this past November. So due process, as I said, there was just one claim in the Gaskin case. It's a due process claim. Due process comes from the 14th Amendment to the U.S. Constitution, which basically says, and I've got a beautiful little graphic there that quotes it, but you can't take away someone's liberty without due process. So taking away someone who's on parole in community supervision, they live in the community, reincarcerating them is taking away their liberty. And so you have to give them due process if you're going to do that, which of course begs the question of what process is due. When considering what process is due, it's really a concept that's flexible. So I have here the 3 F's. When it boils down to it, due process just means fairness, fundamental fairness. And so I think a lot of the concepts that we'll be talking about in a minute as far as what's happening, what needs to change, and what hopefully will change, will be intuitively pretty, make a lot of sense to folks. It's like, oh yeah, as Pat said, notice of the violations. How are you supposed to confront allegations against yourself if you don't know what they are, what the facts are to underscore them? That's just basic fairness. Or, how are you supposed to know whether to waive a revocation hearing or not if you've not been informed of your rights? So you don't know what you are waiving away by signing that form. Again, just basic fairness kind of is the underpinning of the concept of due process. It's also flexible. And so there's a famous quote that says, due process is flexible and it calls for such procedural protections as the particular situation demands. And that can often inure to the benefit of our clients by bending that flexible concept in their favor. In the parole context, there are 2 Supreme Court cases that really set forth the minimum requirements for due process when someone on parole supervision or probation supervision is facing revocation of that. And that's the Morrissey case and the Gagnon case. You'll see they're both from the 70s and they were announced back to back. And Morrissey, I have a quote here in this slide. I had it on the previous slide too. It makes the point that folks, as Pat was describing when he talked about the distinction between probation and parole, folks who are on parole supervision, they were once incarcerated. They were released before the end of their lawful sentence. And so they have less of a liberty interest than somebody who has not yet been convicted of a crime. As a matter of law, they have less of a liberty interest because their liberty is sort of conditional on complying with these conditions of parole, which most often are don't break the law, don't use drugs, don't carry a firearm, report to your parole officer, things of that nature. Sometimes, depending on the individual circumstances or crime, there might be a condition of parole like complete a substance abuse class or something like that. But even though this is not a pure and complete liberty interest, unqualified liberty interest, there's the word I'm looking for, Morrissey, the Supreme Court acknowledged that nonetheless, when you reincarcerate someone on parole, it inflicts a grievous loss on the parolee. And I just find this language so moving because it was so clear and remains so clear to me, and I know Pat will agree, that DOC often overlooks the human impact of what it is doing. And I don't know that they gave a second thought to the kind of grievous loss that they are inflicting on not just our clients, the people on parole who are going back to prison, but their families, their communities, their coworkers, our neighbors. So that's important, right? That is why the government can't just throw people back into prison willy-nilly. That is why they have to give sufficient constitutional protection. So I want to dig in just a little bit on those 2 cases because they are so important and they'll help, help folks understand the changes that were mandated by the court in our case. So first is the Morrissey case. And Morrissey basically set forth the minimum requirements for these two big stages of a revocation proceeding. And Pat already sort of talked about these. We had a little flow chart of what the process looks like. There's a preliminary hearing stage, which is just as it sounds, preliminary. And then there's a revocation hearing stage. And the preliminary hearing stage is akin to a preliminary hearing in criminal proceedings. It's meant to be a way of determining whether probable cause exists that one or more conditions of parole were violated. It's supposed to be conducted, according to Morrissey, at or near the time and place of the alleged violation. And the reason for that, again, is pretty intuitive. You want to conduct this hearing before someone is incarcerated too long, and while evidence is fresh, while memories are fresh before that fades away or evidence gets lost. So it's supposed to be conducted promptly and physically close to the place where the violation occurred. And it's supposed to be conducted by someone who's not directly involved in the case. So it shouldn't be conducted, for example, by someone's direct supervising field parole officer. They're too mixed up in it. It should be their supervisor or another parole officer who's conducting this preliminary hearing where it is conducted. The second stage that Morrissey talked about is the revocation hearing. And this is more robust because that is the stage at which the agency is going to make the determination as to whether parole was violated, and if so, whether it ought to be revoked, right? That's an important distinction because sometimes those two stages of decision-making get conflated, and it's just, do we revoke or not? Well, actually, the parole board can find that somebody has violated their conditions of parole and not revoke their parole. They can continue them on parole and release them to the community. And we'll talk more about timelines, but often when that decision is actually being made, they've already been detained or incarcerated for months. So they have that ability. Again, that decision-making kind of gets conflated. But when a revocation hearing is conducted, here are the 6 things that have to be provided. Notice of the alleged violations. Yeah, makes sense. Disclosure of evidence. All right, so they're not going to hide the ball. They're going to, this is the police report that says that you did X, Y, and Z, and that's the basis for the violation. You're entitled to have that. The opportunity to be heard. This is also a very common fundamental due process right. The opportunity to be heard in a meaningful time and in a meaningful manner. That means the ability to present witnesses, present evidence, to confront adverse witnesses. So if there's a police officer who's testifying or speaking to the parole board and saying they saw you, with drug paraphernalia in your hand, and that's what led them to arrest you, you have the opportunity to cross-examine them. And the hearing body must be neutral and detached. So again, your field parole officer can't be a part of that hearing panel. And when a decision is made, it must be written, and it has to provide the evidence relied upon and the reasons for revoking parole. So these are basic due process requirements for the preliminary hearing and the revocation hearing. 1 year later, before I get that, Morrissey, the court expressly said, we're not deciding right now as to whether due process requires that counsel be provided to people going through the revocation process. But it wasn't very long before they decided that. That was the Gagnon case, which came down the very next year. And in Gagnon, the Supreme Court said, there's not a unqualified right to counsel for indigent parolees like there is in the criminal context, but there is a limited right to counsel that's grounded in due process. And again, this is what I love about this is like so much of it is intuitive. It's like, what good are these rights that we just talked about in Morrissey if the person doesn't have the skill to, implement them, to advocate for them, to navigate this process? What if someone who's on parole supervision has a claim of innocence, or they have an intellectual disability or mental health issues that are going to prevent them from being able to present evidence of their innocence or mitigating evidence, or that make revocation inappropriate for this person? And so in Gagnon versus Scarpelli, the Supreme Court said there are certain circumstances, not every case, but certain circumstances under which someone on parole facing revocation has a right to state-funded counsel. Just like someone who is facing criminal charges that is indigent has a right to state-funded counsel. Those circumstances under which someone has a right to counsel is if they have a timely and colorable claim of innocence, or there are complex mitigating reasons that, again, either mitigate the violation or make revocation inappropriate. The first thing that comes to mind here are maybe issues around substance abuse and addiction issues, and whether there are complex reasons that mitigate someone's use of drugs or alcohol and make revocation inappropriate where treatment might be more appropriate rather than incarceration. And then the court also said when a state agency is making this decision about whether someone qualifies for counsel, they should consider whether the individual on parole is not capable of speaking effectively for themselves. And so what the state agency must do when conducting a parole revocation after Gagnon is they have to screen everybody going through the system to determine whether they meet the Gagnon criteria, whether they qualify for counsel. And if they don't, they have to state on the record why that person does not. This was the most glaring issue at the time that we filed our lawsuit, because they were not screening anybody for counsel. And as Pat said, the incarcerated population and the population of individuals on community supervision have higher incidence of mental health issues and of learning disabilities and intellectual disabilities, which means that they're more likely to need counsel to help navigate this process and protect their rights. And that was just being ignored. And it wasn't being ignored because the DOC wasn't aware of this, because these cases came down in the 70s, right? There's no dispute. There's still good law, pretty easy to understand, pretty straightforward. They weren't doing it at all. And there were even instances that I saw in the records where someone was deemed incompetent and they would shuffle through the system without anyone there to advocate for them or help them understand what was going on. So again, just a reminder of what the problems were in this process. Basically, every part of the cases I was just talking about had an issue here in Missouri: inadequate notice, timeliness, pressure to waive, not applying the right evidentiary standard, not screening for providing for attorneys, and then giving these really inadequate decision notices and making arbitrary decisions. The lawsuit challenged all of these deficiencies. And throughout the course of the litigation, which again was 3 years, DOC changed voluntarily some of its policies and practices. I say voluntarily, but would they have changed it without the lawsuit having been filed? I do not think so. Who can say? But I doubt it. But they did make some changes throughout the course of the litigation, and in fact tried to convince the court that because they made those changes, the litigation should go away. The court disagreed. But when I'm going to talk about these issues sort of step by step, and you'll see where DOC made a voluntary policy change. I'll make a note of it here, and a note of the court's reaction. So we're going to go in it sort of the chronological order. The issues with arresting people and not conducting timely preliminary hearings or pressuring folks to waive their hearings. So there were sort of 3 big problems with that: timeliness, pressure to waive, and notices. During the course, let me back up. When we first filed this lawsuit, there was this little thing called the Red Book. If you go on DOC's website, you can Google Missouri Department of Corrections Blue Book. You'll see a blue book, which is basically a guideline for people who are incarcerated as to what the parole grant process looks like or conditional release looks like. There's also a white book. And at the time we filed the case, there was a red book, which, according to our expert witness, was very confusing, inaccurate, not at all helpful. During the course of the litigation, DOC created a notice of rights form, which was meant to be more straightforward and more accessible and accurate. But there were still a lot of issues with it, and it's confusing the language that it used. And they didn't do anything to change the timelines within which they were conducting proceedings. Their initial policy was they were supposed to meet with and offer a preliminary hearing within 5 business days of someone on parole being taken into custody, being aware of them being taken into custody. Obviously there was often delays as to when they became aware that someone was taken into custody, especially if they were arrested in a county different from the one in which they were being supervised. But technically they were supposed to meet with them with an offer of preliminary hearing within 5 business days of arrest. And then if someone requested the hearing, it was supposed to be conducted within 10 days of offering the hearing. Those timelines were not being followed. People were not necessarily getting a meeting with parole officers in jails within 5 business days. Often, jails would send somebody to DOC before this meeting could even occur, in part because they didn't want to have to pay to hold the person. And so they would send them to DOC too early, and that would mess up the process too. They could often get lost, and it would be a long time before they got to meet with somebody. And then obviously, if you get arrested, in Pacific, Missouri, and you get sent to Bonne Terre to the diagnostic center, your preliminary hearing is not going to be happening at or near the time or place of the alleged violation. And the court said, well, these policies actually are good on paper. Yeah, meeting within 5 business days. If you were doing that, that would be good. That would be enough to satisfy due process. But you're not doing that. And so you have to prove that you are doing that. And I think that this is really great because I know it didn't change what the policies were, but it held their feet to the fire. And the reason it's so great is because in order to arrive at this conclusion, at least with respect to the pressuring issue, and I think we'll probably talk about that again in a little bit, is the judge believed our clients. It's so hard as, someone who advocates for people who are incarcerated to get juries or judges to believe prisoners, basically. And the judge believed our clients. He heard testimony from class members who told consistent stories about not getting timely meetings, not getting notice, being pressured to waive. He read countless affidavits from folks with the same stories. And then we also had a survey conducted of hundreds of parolees reported back the same evidence of pressure to waive, not getting timely notice. And he believed those stories over what DOC said was happening. So that was a big victory in and of itself. The judge said, these procedures are okay on paper, but you're not doing it. You've got to prove to me that you're doing it. The notice issue. Again, this is just a basic due process right. Notice is typically, according to DOC, provided through what are called field violation reports. So if you, let's say you drop a dirty urine, you have to give a urine sample, test positive for meth or something. The parole officer is supposed to prepare this field violation report that contains the factual allegations, the evidence underscoring the alleged violations. That sort of kicks off the revocation process. And that's supposed to be provided within 10 days of substantiating the violation. And then anytime you're interviewed, you're supposed to be provided with that field violation report. Unsurprisingly, we heard consistent complaints that they weren't being provided in a timely fashion. Evidence wasn't being disclosed, so there might be a snippet of a police report in the event of an arrest, but the police report itself wasn't being provided. And then when you had a revocation hearing form, it didn't list the violations at all. So that's the form you'd be presented to request or waive your hearing. DOC didn't change this policy over time. And again, this is an example where the court said, at least in part, what you're doing on paper, what you say you should be doing, that's fine. Yes, providing a field violation report within 10 days of substantiating an allegation, that's fine, but you're not doing that again. So you've got to demonstrate, you've got to prove to me that you're doing what you're doing. And so the judge basically said, I'm going to hold on to this case until I'm satisfied that you're in compliance with all of these policies and procedures. He did order them to make 2 changes. The first is you have to disclose all evidence at least 5 days before a revocation hearing. So as I said before, if there were police reports that were being relied on, they were not being provided to the parolee. And so the parolee might have a revocation hearing and the board is reading from a police report and they have no idea what's in that police report. Judge said that's unacceptable. You've got to provide that to the parolee. And you also have to list all the alleged violations in the revocation hearing form. So again, when people make a decision about whether to waive or have a hearing, they know what the allegations are about, what rights they're waiving away. The Notice of Rights form is something that, as I mentioned before, DOC created during the course of this litigation. Folks were not being informed of their rights. You know, sometimes they'd be provided with that red book, but sometimes it would be after they already waived away hearings. For folks who couldn't read, it wasn't being offered to be read to them. So the court again said, this is okay on paper, but you're not doing it. You have to show me that you're doing what you say you're doing. And the court also said you have to orally offer to read this Notice of Rights form instead of, you know, they would say the Notice of Rights form said, you can have this read to you if you need, just ask. Well, what good is that? If you can't read that notice, you don't know to ask to have it read to you. So they have to orally offer to read the Notice of Rights form. And then the court made, and I'm happy to provide a copy of the order if folks would like to see it. There are mandated changes and then there are recommendations. So the court made some recommendations for changes to the Notice of Rights form to make it easier to understand and consistent with other policies that DOC has. And this was in part based off of testimony from our expert witness who oversees this sort of similar case in the state of Illinois. One of the changes that he recommended they make is they keep referring to the preliminary hearing as either a preliminary hearing or a probable cause hearing, and it's just inconsistent and confusing for a lot of folks. I can't tell you how many people that we talk to that, you know, we would say, oh, did you get your Notice of Rights, or did you know you had a right to an attorney? And they had no idea. Even folks who had been through the process multiple times had no idea. Okay, so the waiver issue, I'm trying to speed through because I know I'm a little behind time. But the waiver issue was a problem that, you know, I think as a lawyer, I was most concerned with proving up because, again, it was something I consistently heard from our clients and from witnesses who'd gone through this. But, you know, at the end of the day, DOC would produce this file that said, look, you signed this waiver form, so you signed away your hearing. As Pat said, fewer than 3% of people on parole even have a hearing. And most of them, and I think according to our survey, it's 83% who said that they were pressured to waive their preliminary hearing, told things like, you know, Pat said, just a technicality. It'll go better if you waive. It'll go faster if you waive. You know, now, you know, if you are, you know, sitting there in jail thinking about how you're missing work, going to lose your job, missing your kids, missing your partner, and you're told, sign this, it'll go faster. How, is that really like a free and knowing and voluntary waiver? You're going to sign it, of course, because you want to get out of jail. All the while you're doing that without having been informed of your rights or the alleged violations. So the court, again, believed our clients. It found that there was pressure being placed on class members, sometimes based on false and misleading information. It was persuaded by really powerful testimony from class members at a hearing back in June, affidavits, and this survey data that I mentioned. And it said, you have to stop that. You absolutely have to stop that. And you have to provide adequate notice of rights. Our expert did a really great job sort of talking about how shocked he was by the very low hearing rate. And he said, you know, that in and of itself is evidence that there is pressure to waive these hearings because so few hearings are even happening. When the hearings do, when the hearings are conducted, they're supposed to be held within 30 days of arrival to DOC custody. So remember, if someone is in jail, they're supposed to have their preliminary hearing in jail. If there's probable cause, they'll go to a DOC, most likely to, or not most likely, to a reception and diagnostic center. And then they're supposed to have a revocation hearing within 30 days. In reality, they're happening on average after 74 days. Most people are waiting have to wait more than 30 days. You know, again, there they sit in prison, not having been determined to have violated their conditions of parole. Some of them might have new charges pending, but they certainly have not been convicted yet. And the court did find that there was an issue with the timeliness of their hearings. I'll say that there was some improvement in the time from incarceration to hearing over the course of the litigation. They still never got like within 30 days for all hearings. And in fact, I'm looking at some data from late 2009, from February through November 2019, there were 3 people who waited over a year for their revocation hearing. Over 150 waited over 90 days, 3 months in prison before they could get their hearing, after waiting who knows how long in the jail. And DOC doesn't count jail time toward that 30 days. So this is a new policy that they passed in the course of litigation, the hearing within 30 days of arrival in custody. And again, this is a common theme I'm sure you all will recognize. Looks good on paper, but you're not doing it. So you need to demonstrate compliance, is what the court said. And again, we've already talked about disclosing evidence, but the timing was something that continued to be a problem for the very few number of hearings that they actually were even being conducted. Our experts said that hearings really should be conducted within 60 days of arrest, or 60 to 90 days of arrest. And so the 30 days of transfer to DOC custody would hopefully mean that folks would fall within that time range of getting a hearing within a reasonable time, which is what the law says has to happen. And then the decision notices. So this is another very obvious problem, because I'll show you what a decision notice looks like. It's got a very lengthy explanation as to the reasons for revoking parole. Here it is. I'll pay you $500 if you can tell me where the justification for revoking this person's parole is. This is it. The decision is not subject to appeal. No explanation at all as to what evidence was considered, what mitigating factors were considered, what conditions of parole were violated, why parole would have to be revoked. That's it. This is the explanation that people are provided if they don't have a hearing, if they waive their revocation hearing. I call it a bare bones boilerplate notice. And the court agreed. This is not acceptable. The court said this does not comply with due process. You've got to provide a written decision that outlines the evidence relied on to determine whether a violation occurred, that outlines the mitigating circumstances considered, and the reasons for revoking. And another thing that you have to do is you got to provide it within a reasonable time, because DOC had no policy as to when it would notify people of decisions. So it says the decision has to be made, or when it would make decisions. So the court said you've got to adopt a policy that says decisions must be made within a reasonable time, and you've got to provide that decision to parolees within 10 days of making that decision. Right to counsel. Again, not absolute. I've already talked about this, so I'm going to try to run through it so I can finish the presentation for folks and not hold you all over too long. But not screening at all, not informing people of right to counsel, not providing attorneys. During the course of litigation, DOC created a screening tool. And what they would do is when they determined someone was eligible for counsel, they'd fax that application or email it to MSPD, to the Public Defender's Office. The Public Defender's Office made very clear from the beginning, we are not representing these individuals. First of all, we don't think we have to. We don't have the statutory authority to do so. And we certainly aren't able to do so. I'm sure everybody on this webinar is well aware of the systemic workload and resource issues that have hounded MSPD for decades. They have criminal indigent defendants on waiting lists across the state, including some who are themselves detained. And they made very clear to DOC that they were not in a position to provide representation to eligible parolees. But DOC did not investigate any other alternatives to providing counsel to parolees who were eligible. They instead either proceeded with proceedings without counsel present, or in some instances, they just released the person and continued them on parole. So the court said, you can't pass the buck. If you're going to run a revocation system, you got to make sure that when someone qualifies for an attorney, they have an attorney there. That's your obligation. That's your responsibility, not MSPD. And if you don't do it, you can't conduct hearings and you can't incarcerate people. This is a huge, huge win. The court also said you got to revise the screening instrument. You got to train people how to screen. So because of how they were doing screening before, they weren't properly identifying who was eligible. They obviously weren't providing a counsel to those who were, but they were also underestimating how many people qualified for an attorney. So this portion of the remedy means that they hopefully will get better at identifying who qualifies. And if those folks don't have an attorney, they can't throw them back into prison. They can't proceed with their hearings. They've got to release them and continue them on parole, which is a really, really great outcome. It's also probably one of the big issues on appeal. And then again, if someone's not eligible for counsel, they got to provide written notice within reasonable time. They weren't doing that before. If someone asked to be screened for an attorney and they didn't qualify, sometimes they weren't told at all. In one instance, they were told after their hearing was conducted that, oh, by the way, you didn't qualify for an attorney. So what about the Missouri State Public Defender? As I mentioned, DOC and MSPD have been in communication. MSPD has said very clearly, we are not going to provide attorneys for parolees who are facing revocation. It's for two reasons. One, it's not within the scope of our authority, which is set by statute. And this statute, which I've got on the screen here, it used to say that MSPD would represent parolees in revocation proceedings. That was removed in 2013 after the Waters decision, which related to the overburdened Missouri Public Defender System. And also they said, even if it were within our authority, we can't do it. We don't have enough attorneys to do this for you. So again, the district court ruled actually twice that DOC, not MSPD, is responsible for ensuring counsel is present when due process requires counsel to be present. I guess one final issue is the appeal process. This is sort of a small issue at the end, but when someone gets a decision, in some instances there is a right to appeal, but this is I think a good example of the cruelty of what DOC policy looks like in practice rather than on paper. There are a lot of times, so the appeal form has to be filed within 30 days of the decision, and there are a lot of times where they wouldn't provide the form until after the 30 days. The court said that's unacceptable. Make the appeal form available the same day they get the decision. And when you deny the appeal, you can't just rubber stamp it. You got to give explanation for the decision. So again, these are powerful things because they're going to slow down the process. They're going to hold DOC accountable. They're going to empower people going through the system, but they're also just very intuitive changes that just, work toward fundamental fairness, basic fairness, which seems like the least the DOC could do when they're going to be throwing people back into prison. Pat, I think you're going to talk about the last couple of slides, and then we'll have time for some questions if folks want to stay on for questions.
Yeah, thanks, Amy. As quickly as I can, we talked about how MacArthur has been working on this case since 2017. The issues, obviously, the constitutional problems go back some 50 years. But where do we stand? We got this great order where Amy went through and the court ordered the state to do these various things to ensure that people's constitutional rights are being protected. But the state has appealed that order. It's an interesting appeal because, again, like Amy said, the state admitted liability in this case. They said folks are not getting their constitutional due process. But then when the court said, okay, how are we going to fix that? We're going to implement these solutions. They said, whoa, you can't tell us to do that. And so they have appealed to the Eighth Circuit. They make two basic arguments. They admitted all the time that there were unconstitutional deficiencies. There were things wrong with their process, but over the course of the litigation, don't worry, we managed to fix all of them. And they also are arguing that we, the plaintiffs, can't sue them without the state public defender being a party to the action because their position, which again has been rejected by the court twice, is that the public defender is the only agency that can provide counsel for these folks. I thought of an interesting detail when Amy was talking about this. Their process was when they found someone eligible for representation, when this person was constitutionally required to have a lawyer, their solution to that was to fill out an application, fax it to the public defender, and then proceed with the revocation as though the person didn't have a right to counsel. They just washed their hands of it and said, well, we gave it to MSPD. We no longer have any responsibility to ensure that this person's constitutional rights are being respected. And one thing to note is that the changes are on hold pending appeal. This happens a lot in litigation. We argued to the court that its remedy should go into effect immediately, and that it shouldn't stay its remedial order, but the court denied that. And so as it stands, this judgment that we got, and that is so good for us and our clients, all those changes are on hold. The state is resisting making these changes, which we and the court have said are required in order to comply with the Constitution. So that's kind of where we stand. And then just so that you all can take some of what you've learned here out into the world, we some action items. And Amy, if you go on to the next slide, what do you do to help in this situation? You know, the court isn't doing it right now because its order has been stayed. I think it's really important to note that the state can implement these changes of its own volition at any time. You know, they aren't just fighting about being ordered to make these changes. They're refusing to do it in the meantime. So, you know, if we can lobby policymakers, we can change the parole revocation system without having to worry about what the federal courts have to say. You can always ask the governor for a pardon or for clemency. Obviously, with the current occupant of the office, that isn't a successful route. But, you know, for folks whose, you know, parole was unjustly revoked, a way to get that remedied is to write to the governor and say, you know, it was unjust, and so you should commute the rest of my sentence or whatever it might be. So on an individual basis, we might be able to advocate for people to the governor. Now, there are some bills that have been pre-filed in the Missouri legislature that are somewhat relevant here. And so if you're the type of person who tracks legislation, contacts your legislators, these are some of the bills that you might keep your eye on if you're interested in this issue. HB 504 would make additional people eligible for parole. It would be people who are convicted of some drug crimes would be eligible for parole after 10 years. HB 277 is another bill that would allow more people to be decarcerated. It would create a special right to a parole hearing for anyone who's 65 or older and has served 30 years in DOC. HB 636 would allow people who are under 18 years old when they were locked up and whose sentences were greater than 15 years to ask the parole board for release after 15 years. That's not something that's automatic. You don't always have the right to ask the parole board to be released. If you have a 25-year sentence, you may not have the right to go in front of the parole board. This law would give more people the right to say, hey, after 15 years, I've rehabilitated myself and I should be granted parole. HB 821 is less relevant. It has more to do with probation than it does for parole, but it has to do with the ability of the state and judges to order that people are remain incarcerated while their parole is being revoked. And HB 50 I included not because it's directly relevant to this issue, but it's relevant to a very similar issue, which is that HB 50 would outlaw the death penalty in Missouri. And, you know, I suppose it's not really decarceration to advocate for ending the death penalty, but it is, you know, consistent with, I think, the thinking that, you know, we don't need to punish people the way that we do, and we certainly don't need to punish them in our criminal legal system where things go wrong all the time.
I know we got started a little late, and so we are over the hour, but if folks want to stay on and have any questions, I'm going to stop my screen share, but more than happy to answer any questions folks have, because I know we did have to expedite things a little bit.
Hear me, Amy?
Yeah.
Okay, cool. My name is Ann Perry, and I have a prison ministry actually here in St. Louis. And so my question is, what is the purpose of someone telling the offenders to go ahead and waive their revocation? Is it because it's easier for them, or in terms of paperwork, or what's the purpose behind that?
Yeah, that's a good question. I mean, I think there are different interpretations that could be made depending on the individual. And I think a charitable one is that, maybe they actually believe that. And, that maybe it does speed things up a little bit more if you don't have to wait for your hearing, because then they've got to schedule it. And since they're not honoring the timelines within which they should be conducting it, it does drag things out more than it ought to, and more than it has to. Because, by the way, across the river in Illinois, where they conduct many, many, many more hearings, they do it a lot faster than they do in Missouri, and they provide attorneys. They screen for attorneys. Not perfect, but it can be done. So, I think maybe in some instances, a charitable interpretation of is that they mean well and they think they're giving good advice, but it's just wrong. In others, I think it's just, they don't want to put in the effort to engage with the individual the way that they would have to if there were a preliminary hearing involved. It's much easier to keep it superficial, to sign this, I can get out of here, I can get on with my day. That kind of lackadaisical approach to detaining people. This is all anecdotal based off of, Yeah, to
piggyback off of what Amy said, I think one thing that we didn't say explicitly, but that underlies our entire presentation here is that there's an assumption within the parole revocation system that the person's going to be reincarcerated. And so if you're working under that assumption, why does it matter whether they have a hearing or not? They're going to go from where they are to prison, and whether they have 2 hearings along the way doesn't really matter if we're just assuming that they're going to be reincarcerated. And that's an attitude that has to change, where litigation can be the start of that, but it requires much more broad strategy to make that stop happening, to make that stop being the governing assumption.
Yeah, and I'm going to put into the chat, sorry, on that the presumption of reincarceration, that something that changed over the course of litigation, which may have sort of stemmed from negotiations that fell apart, obviously, and I can't disclose what those negotiations were, but we were trying to push for graduated sanctions. So many people were being arrested on technical violations, which means you didn't commit a new crime, but you didn't report. Or like we had an example of someone who was violated for going outside of the state because he lived in Kansas City on the Missouri side and he worked in Kansas City on the Kansas side. It's like ridiculous that they would throw that man back in prison for going to do his job, like 5 miles the wrong direction. The same kind of problem in St. Louis, with Illinois right on the other side of the river. So something that they did implement was this matrix, which is kind of hard to understand, but essentially it's a graduated sanctions matrix with hopefully the goal of keeping people out for, these technical violations that are easy to pick up. I see Maria has a question too.
Okay, so this was very good information. I advocate for human rights, prison reform, and I have some people that I'm working with. It didn't necessarily start on the end where their parole was violated. It's just lots of issues going on inside the Missouri Department of Corrections where they're not held accountable, the staff. So one example is 2014 to 2017, there was an inadequate board where they did not have all the board members. Don Rusica was asked to retire or resign because he was playing word games with offenders. They were not allow their due process, like you're saying about the 30 days where they should be able to receive appeals, things like that. And just recently, I'm working with someone who, this was a fight, but he was supposed to, had COVID. He was supposed to come home January 8th. He received a false violation. So I started entering in on that violation, back and forth with the warden, because what this guy was saying was true. They wound up dismissing and expunging the violation. However, they gave him a 90-day setback. So I went back and forth with the parole board, like, how can you get this man a 90-day setback when the case has been dismissed? However, yesterday they let him know that they're going to let him out this month, which is still too long. He was supposed to be out on the 8th. But my question is for like myself as an advocate, organizations that want to help with these very same issues that you're talking about inside the prisons. what would you say would be a good starting point? I'm sure I've made my name clear with the parole board now, but there are so many other people. Like, that really gets to me that you're allowed to do all of these things that you all talked about today from the front end, but also on the back end. Like, you have people that are still there, and we're planning some things in the near future. Like, what about all those people? Even though Don Rusicker was asked to resign, what about all those people that got denied a parole between 2014 and 2017? So, any suggestions with that?
Yeah, that's a big question. It's a hard one. I mean, the first thing is, before we ever do any advocacy on behalf of folks, we always make sure that they are comfortable with it, and we are always very upfront with, like, look, there's always a risk of retaliation. We can't prevent that from happening. And so always making sure that, before you call a warden for somebody or reach out to the parole board, that you've got their, like, consent, that they're on board with doing that, right? Because it's sad but true, sometimes it can backfire. And the other sort of tricky wrinkle to this is that the parole staff, the IPOs, the field parole officers, even the parole analysts who help the board, they are all DOC employees. They're under the Division of Probation and Parole. But the parole board members, they are appointed by the governor. So
Yes.
AM prefects can't tell them what to do. They are very powerful, not as informed because they're former state reps, largely, some former law enforcement. But that sort of distinction, I think, is important to understand. And then legally, historically, they have very broad discretion in terms of granting parole, right? So we've been talking about parole revocation, which is you've already been granted it and now they're trying to take it away from you. But there's an old case from the 60s that clarifies that there's really no right to parole. Missouri doesn't even have to have a parole system if they don't want to have it. Like, federally, there is no right to parole. And so because of that, it kind of gives the parole board a lot of power to run it kind of however they want, which is obviously not great for a number of reasons. I think in other areas where we or family members have advocated on behalf of particular individuals, the squeaky wheel has worked, just calling and not giving up, and calling constituent services and calling the director's office, and keeping a record of those communications that has, in some instances, compelled people to act, but not necessarily in the parole context. I think that's kind of a different beast. And I think they're less likely to change their minds. The parole board is, quite honestly, is my experience. Anyway.
One more question.
I'm not sure I answered your question.
I'm just trying to figure out, there's pure, it's unfair, it's unjust. And I do know, like, just dealing with my advocating with the Department of Corrections, once you can prove that, it kind of get their attention to avoid things like lawsuits and things like that. So when I go in, I just try to deal with the facts. And you're absolutely right about the retaliation, because most of the people that I do advocate for, but I let them know, like you say, hey, this is the risk. And most of them say, hey, I'm already being mistreated. Bring it on. Let's do it. But I know for the sake of time, with that HB 636 that you all mentioned, can you kind of just go over that again?
Yeah, I'd be happy to.
This is
so I'd be happy to kind of explain what that bill would do. So, like Amy said, there's two stages to parole in a way. It's before you're granted parole and then after you're granted parole. We've been talking about after you're granted parole and it's getting revoked. But what HB 636 would do is make more people eligible for parole. So these are folks who were under 18 when they committed the underlying offense for which they are incarcerated, whose sentences were greater than 15 years, all of those people now have a statutory, or would, if this passes, would have a statutory right to go before the parole board and say, I'm rehabilitated, you should let me out. That's not a given. Like Amy said, they don't have to even consider parole for you. And so what 636 would do is make more people eligible to be in front of the board trying to get out of prison.
Okay. Thank you.
I think it was largely inspired. I'm guessing, I guess, but I'm pretty sure it's inspired by Bobby Bostick, who's a case that probably folks have heard about on this call. I know Kenyon knows about, and serving 241 years behind bars for a crime he committed when he was a kid. And the judge who sentenced him said that was a mistake. And so this is basically a juvenile parole bill. It says, kids are different. They need to be given an opportunity to get released from prison at a meaningful time in their lives. And there hasn't been a way to do that for them. So this creates that opportunity for them.
Okay.
And HB 636, as well as HB 277, which Pat mentioned, that's elder parole. Those are both legislative priorities for Empower Missouri this session. We are working to see both of those passed. So if you are interested in following updates on those, we do have them included in our legislative tracker, which you can find on Empower Missouri's website at empowermissouri.org. And we'll be giving regular updates on those bills during our bi-monthly smart sentencing calls. So for anyone on this call who is not a part of that group, it meets on the, I'm going to get it wrong, first, third, and fifth Fridays of the month at 11 a.m. And that information is up on our website as well. So please feel free to join us. We'll be, once those bills are getting hearings and things like that, we'll be updating the community about ways to advocate for them to be to share testimony in favor of passing those bills, and then advocating legislators to get them moving.
That's great. Can I just add one more thing, which is that I think, the parole board is a political body. They're subject to political pressure, and part of that works against our clients' interest because they are afraid they let someone out, that person commits a crime, and then they're going to say, the parole board, why'd you let this person out? So to the extent that we are in a position to counter that narrative, to lift up success stories of folks who were released on parole and did wonderful things, stayed out of trouble, to counter that narrative and put positive political pressure on the parole board. That's another sort of informal way that you can advocate for parole reform, in a way, sort of trying. That's the bigger, harder shift to make, is the culture shift. And I think by uplifting those positive stories, that's one way to maybe inch things along in the right direction.
Thanks for that, Amy. And thank you so much to Amy and Pat for that awesome presentation. Wow, we're so grateful for the opportunity to learn from you. Apologies again to everyone for our technical difficulties. Thank you for sticking with us and finding the new Zoom link and meeting us here. We did record today's presentation, so we will be sure that gets up on the website and is sent out. So if there are others that you think would benefit from this information, please do feel free to pass it along. And thank you so much for coming.
Thank you.
Have a great rest of your
Thanks,
day.
everyone.
Thank
Take
you,
care.
everyone.